Next session, managing. I'll be managing the managing. I'm chairing the session. My name is Lee Sackett. And we have three speakers this afternoon. First off will be, and this is in no particular order except the order that was in the program. First off will be Mia McCulloch from Queensland South, just here on my left. Then after that will be Pascal Taplin from North Queensland now. Yes, recent move. And that will be followed by Emma King from NLC. I'll turn it over to them, and then they'll just run through their presentations, and if you have a really pressing question, we can jump in with that, but by and large, let's try and move through the presentations and have questions at the end. Thank you. Mia.
Thank you. Yes, so I'm Mia. I'm at QSNTS. I'm just going to give a bit of an overview of how we're approaching compensation at QSNTS, finishing with some of my own thoughts in terms of research-focused questions ahead. So just for a bit of context, in Queensland, and in our region, which is from Mount Isa across to Rockhampton and down to the Queensland and Northern Territory borders, following Griffith's judgment and then the appeal in 2019, there was a fair bit of attention in the media about native title compensation, and we received and continue to receive quite a bit of interest from our constituents, as you can imagine, wanting to know whether they're eligible for compensation, and if so, how to go about lodging a compensation claim. And I expect this is quite similar across the board, across Australia, different regions. So being able to provide an accurate depiction of what some of the challenges, the risks, as well as the entitlements might be associated with compensation from group to group, of course, is quite complicated to even estimate at this point. Not just because there is so little jurisprudence to work off, but because in terms of cultural loss, for instance, each case is going to be unique depending on what acts have occurred, where, when, and what evidence there is to support the level of impact such acts have had. So, and beyond our duty to ensure that groups properly understand the risks and costs associated is of course an interest in safeguarding individual groups as well as native title holders across the region and the country from detrimental outcomes through jurisprudence that puts all future compensation claims in a disadvantage through judgments, equivalent to compensation, equivalent to yada yada and the like. So in the interest of getting things right and advancing cases with caution and coordination, QSNTS has supported efforts to develop an Australia-wide community of practice for native title compensation. So cooperating with, I think it's been mentioned in the last couple of days, with CNTA, IATSIS, the NNTC, anyone else? So yes, for a compensation working group. And so the QSNTS approach within our region, one of the main messages to our constituency up until this point has been about encouraging patience. Explaining that, the law around native title compensation to be complex and will develop further over time, and pointing out that any acts that are compensable have already occurred and compensation will be calculated with interest. Though I think it's important to note the tension here, obviously, and Mortimer touched on it, there's, especially from a research perspective, as time ticks on, the level of knowledge that goes with the loss of key elders and informants can have a great impact on the sort of evidence that you can collect for compensation. So patience, but understandably not too patient, concurrent to this cautious approach by the rep body, following the 2016 judgment, there were 3 compensation claims lodged in Queensland, 2 of which fell into the QSNTS region. Neither of these were represented by QSNTS, and they were discontinued the same year they were lodged. But it gives us a glimpse, perhaps, of the eagerness of some to have their matters of native title heard. and resolved. So again, since the 2019 judgment, and despite our messaging, there's been again another 3 claims lodged in Queensland, all within the QSNTS region, none represented by QSNTS. So to date, Queensland South has been a respondent to 2 of these, both instances where there appears to be defects in the proceedings that could result in undesirable outcomes for the claimants and for other Indigenous stakeholders. So for QSNTS, preparing for compensation has involved not just preparing to prosecute claims on behalf of our clients, but rather wearing a number of different hats for different circumstances. So this includes educating our constituents about the risk and potential benefits of native title compensation claims, participating in community of practice, sharing in knowledge and experiences to assist building sectorial capabilities, and advocating for the development of a non-litigated approach so that compensation entitlements may be negotiated with the state, Commonwealth and other parties via non-litigated means, such, the alternative settlement framework conversation. So in terms of legal proceedings, joining as a respondent to a claim not represented by us to address technical issues such as claim authorisation process requirements, and joining as a respondent to a claim on behalf of clients with interest in a claim who are not otherwise being properly represented by an applicant, noting that QSNTS obviously doesn't dispute the right of traditional owners to appropriately seek compensation only where there appears to be defects in the proceedings. Finally, preparing to prosecute claims on behalf of clients within our region, including all the background work necessary to formulate and prosecute a claim. So this is kind of where I've had more involvement. So just in terms of how we've been doing this, in response to these various areas, areas of involvement, we've set up an in-house compensation team shortly following the handing down of the appeal judgment in 2019. So the team is made up of myself as in-house anthro research officer, and a legal officer who specialises in tenure and is has a very good understanding of what information we need to assess an area for compensable acts, and how to go about obtaining such information, which is quite the task. And then, of course, under the direction of the PLO and COO and CEO who are here today. So since 2019, the project has met with a few false starts. Our first aim was to ensure that we understood as best as possible what we were dealing with in terms of compensation-based challenges of our region. So to do so, we'd initially hoped to develop 2 case areas that would provide some insight to some of the challenges likely to arise in the Queensland context. To arise in different parts of Queensland. So in broad terms, the idea was to begin assessing one rural and one urban area. However, the resources required to do so, in particular access to and costs associated with accessing information from the Titles Department, were just too great to be focusing on not be focusing on just one particular compensation claim area. So we've now narrowed our focus again to the starting point of just one project at present, and we're working with one PBC within their determination area, and we're in the thick of that tenure assessment. So our next step will be to return to the group with our analysis and assist them to make decisions about how they would like to proceed. With maybe this is litigation, maybe this is agreement with the state or otherwise. So from a research perspective, in terms of preparing for compensation work, for me, the work from 2019 through into 2021 really has involved just a lot of reading and a lot of thinking. A big part of this initially was getting across and understanding the Griffiths judgments, obviously, the legal and anthropological arguments put forward, and then sharing in discussions around key aspects of the judgments within our team. Other reading included a lot of what was covered in Hilton's literature review last year that was circulated, And then also keeping an eye out for relevant readings on impact of damage and loss, concepts of shame and feeling sorry, as David was talking about, and reparations and the like, which until now, in my experience of working at QSNTS, have sat much more in the peripheries of connection research, focused obviously on the ongoing connection to country rather than what has been lost and the impacts of this. So, reading through a lot of this material, my recurring thoughts have been around whether there is scope to, and indeed a need to, challenge or further develop some of the concepts laid down in Griffith, especially those kind of interest to me around cultural loss. Another has been trying to get my mind around just how you would work out some kind of scaled approach for formulating cultural loss compensation entitlements for an alternative settlement framework. This is something that's a conversation been happening in our workplace, talking about drawing from personal injury law and the idea of tariffs and that sort of thing. I also completed a kind of a very basic tenure analysis course of different types and their various implications in the context of native title compensation. In Queensland, the state has a series of online modules that were quite useful for me. And also very helpful, of course, from early last year, CNTA began coordinating a series of NTRB research manager Zoom meetings, which I was invited to participate in. So these meetings attended by in-house anthros, consultants and other invited guests, covered a range of topics within the broader theme of compensation. These sessions were very useful for expanding and in some cases focusing in on thinking on a whole range of questions, challenges around compensation. So some of the standout topics for me included some of what, sorry guys, some of what David Trigger actually was touching on again today about useful compensation project terms of reference to a consultant, what those might look like. Another was the discussion led by Mick O'Kane around the different areas of risk surrounding compensation research and what we might be thinking, what we ought to be thinking about. Another standout discussion for me was around the implications of having the right to take for any purpose in native title determinations recognised when calculating compensation. So in terms of what's next for research, very quickly, sorry about that, I might just have to very quickly, so this will involve obviously for research going through all our in-house materials, so looking at what purpose materials have been prepared for, whether they can and should be relied on, and if so, what permissions might be required for us to do so. Then, upon reviewing materials, really assessing what information gaps remain and thinking about how best to elicit such evidence. I have some kind of thoughts about why this is an important step, and some might disagree for various reasons, but I'll just skip to just some final thoughts. I've been thinking about, I've found it quite challenging being a sole anthro working on this in-house. I'm all for the kind of interdisciplinary approach that we're taking at QSNTS, but in terms of collaborating and working and thinking in terms of getting across new topics, it's harder when conversations are limited to those of other disciplines and framed by organisational legal priorities. So not having more anthropologists getting across this topic within the organisation means not having that luxury of cohort discussions. So I've been thinking about how we might be able to bring more in-house anthropologists in on these discussions and continue to build up internal capabilities. So doing so would also safeguard against loss of corporate knowledge and some, if someone from a small team is kind of left or no longer able to work on the project. It also means more in-house anthros have the capabilities to assist when they've been working in the connection phase, as they transition across of our whole of client kind of model. And of course, we know the day-to-day conversations with our constituents don't just happen between the PLO and individuals. You know, they're happening with the legal officers and the anthros and the community relations officers. So, so the more people across the organisation with basic understanding about, you know, compensation and going along with it, I think the better. So, sorry for being so long. Yeah, so I guess that's kind of where I'm thinking about how do we, you know, given our finite resources, how do we really bring as many people in? And I think, you know, yeah, I'm interested to know how other rep bodies are kind of doing it, I suppose. Thank you.
Yes. Thank you, Mia.